The International Court of Justice in The Hague has partially granted Ukraine's request for preliminary measures against Russia under the International Convention of the Elimination of all forms of racial discrimination. However, the court said that it wouldn't impose measures ordering Russia to stop funding and equipping pro-Russian separatists as part of the case brought against Moscow by Ukraine. The decision concerned the choice of provisional measures based on claims that Russia supports terrorism in Donbass and ethnic discrimination against Ukrainians and Crimean Tatars in annexed Crimea. Moreover, the ICJ expects Ukraine and Russia to both uphold and implement the Minsk agreement. And we have with us Mykola Gnatovskiy, who is one of the best Ukrainian international lawyers, to explain the significance of this case, what it means. So, Mykola, thanks a lot for talking to us. There are always debates in Ukraine. Has Ukraine lost or won in this case? What it all means, how significant is that? Can you elaborate?
Yes, thank you very much. Well, this case is, of course, a case that should be viewed in a broader context of the various efforts by the Ukrainian government to have recourse to various judicial mechanisms that exist in international law. When it comes to the International Court of Justice, the government chose to invoke the International Convention on the Elimination of all forms of racial discrimination, as well as the International Convention for the Suppression of the Financing of Terrorism, for the simple reason that these were the two conventions where Russia has already beforehand agreed to the jurisdiction of the International Court of Justice in respect of all possible disputes arising from these two conventions. So at this stage, Ukraine requested provisional measures that is a very, very preliminary stage of the proceedings. So at this stage, it is really impossible to speak about winners or losers. Definitely, there might have been a big loss, of course, for Ukraine should the court decide to strike out these cases and to basically to refuse justice to Ukraine exactly on this stage. This is a rare occasion, but in principle that is not impossible. The court did that in other cases sometimes. So here, of course, as long as the case goes on, we can't say that there are winners or losers. Now, concerning the provisional measures ordered, I think Ukraine can consider it to be a success that the measures ordered under the Convention for the Elimination of all forms of racial discrimination, that these measures are quite specific. It is not just a general measure that the parties should refrain from aggravating the dispute or making it more difficult to resolve. This measure also applies to both conventions, and this measure was also ordered by the court. But it's a specific measure concerning the Crimean Tatars, and in particular their representative body, the Mejlis, and also it is a specific measure concerning the education in the Ukrainian language. So it is good that these specific measures have been indeed ordered. As regards the other convention on the financing of terrorism, this convention was very new for the court in the sense that there hasn't been a case directly dealing with the interpretation of this convention. So the court has entered an unknown territory, and the court had to be very careful and very prudent at this stage, before, without prejudging its future decisions, its future judgments on the existence of the jurisdiction of the court, because it is evident that Russia will, of course, submit preliminary objections regarding the jurisdiction, and also possibly, if that measure is, if that stage is successfully passed by Ukraine, then also the court didn't prejudge its further deliberations on the merits of the case. So, in that respect, of course, there are some very useful hints for Ukraine. Regarding the preparation and the drafting of its memorial for the court, regarding the Convention on the Elimination of all forms of racial discrimination, but also regarding terrorism, because the court has already in a way, I showed how it is going to interpret the definition of terrorism and the definition of financing terrorism that are present in the convention. And this also requires Ukraine to be very specific and to find
Mykola,
good evidence.
that's exactly
Yes.
what I'd like to clarify. So why those claims that Russia supports terrorism in Donbass were not supported? Some people were saying that maybe Ukraine was too ambitious to really, raise that particular issue, but the government has chosen that particular claim. So what it mean, how would you interpret that?
Well, in the first place, the court did not consider any of the claims made by Ukraine on merits. Okay, so this is very important to know. It was just the preliminary measures, whether the court can already, on the basis of what there is before it, in a very limited time, order preliminary measures. And in respect to this convention, the court wasn't in a position to do that because the situation is indeed very complex. It is not only about terrorism. It's also about an armed conflict, and this is what the Russian agents before the court tried to argue, that this entire situation in the eastern regions of Ukraine, that it falls under the scope of international humanitarian law. Of course it does, but not only international humanitarian law. Acts of terrorism are possible. They can be committed, and unfortunately they are committed in armed conflicts, making it also a specific measure. A specific case that could be raised under this convention. So now for the court, it was too early to judge. And that's why the court decided to be cautious. So this is how I interpret its order.
And finally, to what it all will lead? What is next? What is next?
Well, what is next? The next is the court has to fix now timing for the parties to prepare, for Ukraine to prepare its memorial. That is the main document, the main submission to the court. And then also to the Russian Federation to prepare its counter-memorial. So it will take time. It will take, I think now with a very possible stage of establishing jurisdiction of preliminary objections by the Russian Federation, that only the stage of preliminary objections will take, in my opinion, at least 2 years, maybe 3 years.
And if we go beyond ICJ, then what? What are the other ways that the countries, like Ukraine in this case, can, ask for justice?
Well, Ukraine is already doing that. Ukraine is doing that in the European Court of Human Rights with 5 interstate applications concerning the Russian Federation. Ukraine is already doing it in the arbitral tribunal created under the United Nations Convention on the Law of the Sea. Ukraine is doing that in various international fora that deal with investment claims. So this is a very complex picture. It is not just the International Court of Justice.